Chapter XVI, Indicia or Badges of Fraud, SS 224. The creditor's embarrassments, proof of fraud, the practical difficulties which a creditor encounters in seeking to discover equitable assets, or to reach property fraudulently alienated by the debtor, have already been the subject of comment. A transaction or conveyance having every appearance of fairness and legality, and to which the ordinary presumptions of good faith attach, is usually presented at the threshold of the litigation. The debtor, and the fraudulent alienees acting in collusion with him, will be found, in most instances, to have taken every precaution to hide the evidences and traces of their frauds, and, ordinarily, the guilty participants develop into witnesses prolific of plausible statements and ingenious subterfuges devised to uphold the colorable transactions. An intent to defraud is not published to the world, but, on the contrary, the usual course of the participants is to give to the contract the appearance of an honest transaction, and to have the conduct of the interested parties correspond, as far as possible, with a bona fide act. Parties practicing fraud almost uniformly resort to expedients to conceal the evidence of it. Fraud always takes a tortuous course, and endeavors to cover and conceal its tracks. Lord Mansfield said, "Hardly any deed is fraudulent upon the mere face of it." Chief Justice Bricknell observed, "Where a fraud is contemplated and committed upon creditors, concealment of it is the first, and generally the most persistent, effort of those who are engaged in it. Publicity would render their acts vain and useless. Leaving direct and positive evidence accessible to those injured by it would be the equivalent of a confession of the culpable intent, and of the defeasible character of the transaction. There are numerous circumstances, so frequently attending sales, conveyances, and transfers intended to hinder, delay, and defraud creditors, that they are known and denominated badges of fraud. They do not constitute or not elements of fraud, but merely circumstances from which it may be inferred. The question presents itself: how can a creditor most effectually thwart the deep-laid schemes of the debtor and his fraudulent alienees, and overcome the usual presumptions of honesty and good faith which the parties will invoke? No witness can look into the minds of the parties and thus be able to swear positively that they intended to defraud the creditors of the vendor. And, hence, as we have already shown in this discussion, fraud can generally be established only by facts and circumstances which tend directly or indirectly to indicate its existence. Experience shows that positive proof of fraudulent acts is not generally to be expected, and for that reason, among others, the law allows a resort to circumstances as the means of ascertaining the truth. A deduction of fraud, says Kent, may be made not only from deceptive assertions and false representations, but from facts, incidents, and circumstances which may be trivial in themselves, but decisive evidence in the given case of a fraudulent design. Circumstances altogether inconclusive, says Clifford, J., if separately considered, may, by their number and joint operation, especially when corroborated by moral coincidences, be sufficient to constitute conclusive proof, or they may be a link in a chain, which, altogether, is very strong, Wills says. Although neither the combined effect of the evidence, nor any of its constituent elements, admits of numerical computation, it is indubitable that the proving power increases with the number of the independent circumstances and witnesses, according to a geometrical progression. Such evidence, in the words of Dr. Reed, may be compared to a rope made up of many slender filaments twisted together. The rope has strength more than sufficient to bear the stress laid upon it, though no one of the filaments of which it is composed would be sufficient for that purpose. It can seldom be the duty of the court to instruct the jury that a single fact will warrant the jury in finding fraud. All the facts surrounding the transaction must be taken into account collectively. The judgment must be based upon all the circumstances of the particular case, the frequency with which fraud is practiced upon creditors, the difficulties of its detection, the powerful motives which tempt an insolvent debtor to commit it, the plausible casuistry by means of which it is sometimes reconciled to the consciences even of persons whose previous lives have been without reproach. These are the considerations which prevent the court from classing it among the grossly improbable violations of moral duty, and therefore judges often presume it from facts which may seem slight. Fraud, says the Supreme Court of Iowa, cannot always be shown by direct evidence, but is usually proved by circumstances. Neither can the knowledge of or participation in fraudulent designs and transactions be proved in many cases except by circumstances. The very charge of fraud implies color and disguise, to be dissipated by indicia alone. The signs or earmarks of fraud instanced in Twin's case have already been given. and should be kept fresh in the memory of parties interested in this class of litigation. Mr. Roberts says that the general conclusion to be derived from this remarkable case is that evidence of the fraudulent intent supersedes the whole inquiry into the consideration. For no merit in any of the parties to a transaction can save it if it carries intrinsically or extrinsically the plain characters of fraud. It may be observed that extrinsic proof of fraud can rarely be found unless it be in cases where the possession of the debtor contradicts the visible purport of an absolute conveyance. SS 225. Badges of fraud defined. The possible indicia of fraud are so numerous that no court could pretend to anticipate and catalog them. They are as infinite in number and form as are the resources and versatility of human artifice. The statutes of Elizabeth produced the most beneficial effects by placing parties under a disability to commit fraud and requiring for the characteristics of an honest act such circumstances as none but an honest intention can assume. A badge of fraud was said by Chief Justice Pearson in Peebles v. Horton to be a fact calculated to throw suspicion on the transaction and which calls for explanation. Substantially the same language is used by Elliott J. in Sherman v. Hogland, so in Pilling v. Otis, the court in construing the meaning of the expression badge of fraud as used in the charge of a judge, said, "It does not mean that the evidence must be conclusive, nor that it must require the jury to find fraud, but only that it is one of the signs or marks of fraud and has a tendency to show it. There may be great difference in the weight to which different facts constituting badges of fraud are entitled as evidence. One may be almost conclusive, another furnish merely a reasonable inference of fraud, yet both would be badges of fraud, and either might be so explained by other evidence as to destroy its effect. The books accordingly speak of strong badges and slight badges of fraud, of conclusive badges, and badges not conclusive, meaning by the word badge nothing more than that the fact relied on has a tendency to show fraud, but leaving its greater or less effect to depend on its intrinsic character. The expression is used to distinguish the lighter grounds on which fraud may be established as distinguished from the cases where the fraud is apparent upon the face of the instrument and necessarily involves its invalidity. The circumstances which the law considers badges of fraud, and not fraud per se, should, as we shall see, be submitted to the jury so that they may draw their own conclusions. Where, then, a creditor shows indicia or badges of fraud, the burden rests on the grantee to repel the presumptions which the facts so shown generate. It may here be observed that when the consideration for the transfer is clearly established, and the transaction is in effect a preference, it will not be affected by any weak, foolish, or even criminal conduct in the way of an attempt to sustain the case by manufactured evidence. SS 226. Question for the jury. The question of fraud in a transfer must usually be submitted to a jury, save in a few cases where the transaction is manifestly fraudulent upon its face. The distinction between legal and equitable jurisdiction as to this has already been pointed out, and where the suit is in its nature purely equitable, the judge or chancellor is responsible for the decision, though, of course, he may secure the aid of a jury to pass upon framed issues. Otherwise, the jury must be permitted to consider and draw their own inferences from badges of fraud, and the court should not interfere to formulate conclusions for them. To say that badges of fraud constitute fraud in themselves would be to carry the doctrine beyond the limits of reason or authority, and to shut out the light of wisdom and truth, where the entire suit is tried by and submitted to the court, without the aid of a jury, as is frequently the case in equity. The same consideration and effect should be given by the court to badges of fraud as though a jury had been summoned. SS 227. Circumstantial and direct evidence. In Kempner v. Churchill, it appeared that the purchaser said to the debtor, "You had better not delay this matter. You had better let me have the goods and put the money in your pocket, and let the creditors go to the devil." The circumstantial evidence, which was held ample to confirm this direct evidence of fraud, was as follows. First, false receipts given for full value on Saturday. Second, account of stock made out on Sunday. Third, removal of the goods into a cellar on Monday. It is true the fraud must be in the inception of the transaction, but the subsequent acts of the parties are calculated to explain the motives which actuated them in the beginning, and give tone to the then original purpose. SS 228. Recital of fictitious consideration. Let us now proceed to consider more minutely the particular circumstances and surroundings of a transaction which constitute badges of fraud, or awaken suspicions or create presumptions of the existence of fraud. A false statement of the consideration of a mortgage, or of a conveyance or transfer, or the creation of a fictitious indebtedness, is a badge of fraud, and is a proper element for the consideration of the jury in determining the bona fides of the transaction. Such a recital does not usually render the instrument void per se, and in some instances the transaction will be allowed to stand for the amount of the consideration given, and will be void only for the excess, so the issuing of an execution for an excessive amount will, in the absence of bad faith, avail the plaintiff to the extent of the debt remaining due. It may be observed here that the recital of the excessive consideration must be intentional, and not the result of a mere mistake in computation, and both parties must have participated in the fraudulent purpose. Hence, where a wife is ignorant and innocent of fraud, the insertion of an inaccurate or untrue recital in a settlement will not vitiate it. An immaterial misrecital will not be regarded. It is not our purpose, however, to lead the reader to consider an exaggerated or false recital of consideration as an unimportant factor in proving fraud. Far from it. In Hawkins v. Alston, Chief Justice Ruffin forcibly said, "No device can be more deceptive and more likely to baffle, delay, or defeat creditors than the creating encumbrances upon their property by embarrassed men for debts that are fictitious or mainly so. The false pretense of a debt, or the designed exaggeration of one, is an act of direct fraud." Mr. May observed that the fact that confession of judgment covers more property than is necessary for satisfying the debt is a suspicious circumstance. Sharswood, J., declared that a judgment confessed voluntarily by an insolvent or indebted man for more than is due is prima facie fraudulent within the statute of 13 Alis. C5. Then in Warwick v. Petty it is asserted that a judgment laid upon property of a debtor for more than was actually due and owing is a clear violation of the policy of the law and is fraudulent and subject to attack by junior creditors. The judgment, however, must be knowingly, intentionally, and fraudulently obtained for a greater sum than was due, a transaction which on its face speaks an entirely different language from the real one will always be viewed by the law with the highest degree of distrust and disapprobation. And will be the object of doubt and suspicion, though, as we have seen, suspicion alone is insufficient to establish fraud. It results, then, from a review of the authorities, that a false recital of consideration in an instrument, in the absence of explanation, justifies a finding of fraud, that the misrecital must be intentional and not accidental, and is subject to explanation, and that the evil design must be mutual, otherwise the transaction will stand against creditors except as to the excess. SS 229. Antedating instrument. Antedating an instrument seems to be regarded as an indicium of fraud, and testimony tending to establish a fraudulent antedating of a paper is competent. Antedating a mortgage, though very improper, does not, however, affect a mortgagee who is not privy to it. It may be remarked that the date of a deed is not generally regarded as an essential part of the instrument. It may be good with an impossible date, or have no date, and though the date is prima facie evidence of the time of delivery, it may be contradicted. SS 230. Description of the property. A suspicion or inference of fraud is sometimes predicated of a loose and vague description of the goods or property conveyed. All the entire stock of goods in the possession of the said Lee, in his store in the city of Williamsburg, were the words used in Lang v. Lee, and in commenting upon the case the court said, "Does this look like a real bona fide transaction?" A clause in a mortgage by which after acquired property was attempted to be covered was regarded as a feature for the consideration of the jury in Gardner v. McEwen. So in a case in Tennessee, in which the description in the conveyance was so indefinite and general that it was impossible to designate the property, this was considered a circumstance to be taken into account by the jury as an evidence of fraud. Still, it does not follow by any means that an imperfect description of property in an instrument is of much weight as a badge of fraud. Carelessness in the character of the description in conveyances of realty, or in bills of sale, or mortgages of personalty, is very common in transactions concerning the good faith of which no question can fairly be raised. Misdescriptions are often the handiwork of honest but blundering scriveners. SS 231. Conveyance of whole estate. Lowell, J., observes, "I have often decided that the conveyance of the whole property of a debtor affords a very violent presumption of a fraudulent intent so far as existing creditors are concerned." In Bigelow v. Doolittle, however, the court refused to charge that the conveyance of the whole property of a debtor affords a very violent presumption of a fraudulent intent so far as existing creditors are concerned. In sustaining the ruling, the appellate court observed that the generality of the conveyance was merely a circumstance to be considered by the jury in connection with all the other facts of the case. In determining whether or not the sale was fraudulent, Lyon J. said, under some conditions the jury might regard such conveyance as raising a very violent presumption of fraud, while under other indifferent conditions the jury might properly determine that it was but a slight indication of a fraudulent. Such a transfer must, however, be regarded as altogether unusual and extraordinary. The instances in which such transactions would occur in the usual course of business are very infrequent. And when the alienation proceeds from an embarrassed debtor, it creates a presumption of dishonesty and fraud. The transfer, however, is not to be declared void as matter of law under such circumstances. Hence, a sale by an insolvent debtor of all his real and personal estate, taking back notes payable in 6, 12, and 18 months, is not per se fraudulent. To avoid it, there must be a finding of an actual fraudulent intent. When questions of relationship intervene, the motive for making these absolute conveyances becomes important. Hence where, pending a suit, a debtor transferred all his property, save that which was exempt, to his wife and hired out to her for his board, clothing, and lodging, the transaction was held to afford grounds for suspicion and to call for satisfactory proof of good faith and fair consideration. Commenting upon the effect of the generality of the gift, Mr. May says that it is, when taken in conjunction with other circumstances, a mark of fraud for dolus versitur in generalibus. Yet it is no concluding proof either under this statute 13 alis, c5, or by the common law. Then, as we have seen in Twin's case, the very first mark of fraud specified was that the gift was general, without exception of the donor's apparel or of anything of necessity. Chief Justice Marshall, in the leading case of Sexton v. Wheaton, observed, the proportional magnitude of the estate conveyed may awaken suspicion and strengthen other circumstances, but, taken alone, it cannot be considered as proof of fraud. Among the prominent badges of fraud affecting a conveyance as to subsequent creditors may be mentioned the contracting of debts and engaging in a hazardous business or speculation, with the intention of shouldering the risk of loss upon creditors. The cases and principles appertaining to this subject have already been considered. To this class of evidence, McCrary, J., adds another badge, viz., the fraudulent disposition of the remaining estate of the grantor very soon after the conveyance. SS 232. Inadequacy of purchase price. As has already been shown, to enable a creditor to invalidate a sale of property, tangible facts must be proved, from which a legitimate inference of a fraudulent intent can be drawn. It will not suffice to create a suspicion of wrong, nor will the jury be permitted to guess at the truth. Mere proof of inadequacy of price by itself has been considered insufficient to implicate the vendee in the fraudulent intent, or to impeach his good faith. An inadequacy of consideration, unless extremely gross, does not per se prove fraud. It must appear that the price was so manifestly inadequate as to shock the moral sense, and create at once upon its being mentioned a suspicion of fraud. It is even held that in the absence of other evidence tending to show fraud, the court will not deem inadequacy of consideration sufficient to do so. Gordon, J., said, other things being fair and honest, mere inadequacy of price cannot, of itself, beget even a presumption of fraud, much less is it per se fraudulent. Still, authority is abundant to the effect that where a creditor or purchaser obtains the property or estate of an insolvent debtor at a sacrifice or an under rate or value, there is a strong and even violent presumption of a fraudulent intent. J. Thus, where a first lien for $1,200 on a farm worth $13,000 was transferred for a consideration of $400, this was considered evidence of fraud which must be submitted to a jury. Again, it is more strongly stated in Davidson v. Little, that the sale of lands or goods by an indebted person for less than their value is ipso facto a fraud in both vendor and vendee. Where the value was $7,700 and the estimated consideration $1,537, it was held to be conclusively fraudulent. The difference was regarded as so great as to shock the common sense of mankind, and furnish in itself conclusive evidence of fraud. The question, however, is usually submitted to the consideration of a jury to determine the intent of the parties, and is almost always linked with other circumstances or indicia of fraud. Inadequacy of consideration is a fact calling for explanation, and is often treated as a badge of fraud. Insufficiency of price and insolvency of a debtor. Say the Supreme Court of California, may be circumstances more or less potential in the determination of fraud as a question of fact, but failure of consideration is not in itself sufficient to justify a court in finding fraud as matter of law. SS 233. Transfer pending suit. The transfer of all, or, according to some authorities, of a portion of a man's goods during the pendency of a suit against him is a mark of fraud. One of the circumstances specified in Twin's case was that the transfer was made pending the writ. This fact usually induces the suspicion that the conveyance was made to secure the property from attachment or execution in the pending suit, and to hinder, delay, or defraud creditors. This inference may of course be rebutted. In Ray v. Roe ex tem. Brown, the court said that the pendency of a suit was one of the many badges of fraud which would induce a court of equity to set aside a conveyance, or a jury to regard it as covenous. In Sheen v. Shea, it is characterized as only one of the badges. The court further said, the deed may be shown to be fraudulent and void as to creditors when no suit was pending to recover the debt or damages when it was made. The pendency of a suit is a warning to a dishonest debtor to make haste to alienate and cover up his assets. While the service of process in a suit does not usually create a lien upon the defendant's property, and the doctrine of lis pendens is limited in its application, yet transfers pending a suit are justly scanned with very great suspicion, and where it is certain that judgment would be rendered against the vendor, and evidence of inadequacy of consideration is adduced, the courts will conclude that the conveyance is colorable, and made with a view to hinder, delay, and defraud creditors. Mr. May states the rule to be that where the conveyance is made pendent light, it is, when coupled with other circumstances, suggestive of fraud, but where the consideration is adequate, not a strong mark of a fraudulent intention. This, however, can scarcely be regarded, under the American authorities, as giving this important element of proof its proper weight. SS 234. Evidence of secrecy. An unusual degree of secrecy observed between the parties in the making of the sale is a badge of fraud, and the secret removal of the property immediately after the sale indicates a dishonest purpose. Circumstances indicative of concealment, or of a design to give a man the appearance of possessing property which he does not own, are evidences of fraud, and are proper for a jury to weigh. Secrecy is a circumstance connected with other facts from which fraud may be inferred. An agreement, however, to conceal the fact of a purchase is not per se fraudulent, but is merely matter of evidence in favor of avoiding the sale, which, although perhaps very strong, is still capable of explanation. In Haven v. Richardson, the court said, secrecy is not of itself evidence of fraud. It is likely to accompany fraud, and may give force to other evidence, under particular circumstances. Thus it is held in Massachusetts that an arrangement or understanding in regard to withholding mortgages from record until the mortgagors should have trouble did not render the mortgages void, but was a matter entitled to consideration by the jury in passing upon the question of fraud at common law. On the other hand, an agreement that the transaction is to be kept secret until the debtor has an opportunity of escaping beyond the reach of process issued by his other creditors, or by which the deed is not to be offered for record until the other creditors threaten suit, will render it fraudulent. Secrecy in such cases is a part of the consideration. The transaction is contaminated by it, and ought not to be regarded as bona fide. SS 235. Suppression or concealment, subsequent fraud. As long ago as the case of Hungerford v. Earl, it was held that a deed not at first fraudulent may afterwards become so by being concealed or not pursued, by which means creditors are drawn in to lend their money. This doctrine has been repeatedly recognized and reaffirmed in different forms in state and federal tribunals. In Coates v. Gerlach, it appeared that a deed of land had been made by a husband directly to his wife. The deed was dated March 23, 1857, but was not filed for record until December 2, 1857. Over 8 months thereafter, on Jan. 21, 1858, the husband, professing to act as the agent of the wife, effected a sale of the lands to a third party. The creditors of the husband attached the monies in the hands of the vendees, and a contest arose as to which had the better right to the proceeds of the sale. Touching this controversy, Strong, J., said, "There is another aspect of this case, not at all favorable to the claim of the wife. It is that she withheld the deed of her husband from record until December 2, 1857, in asking that a deed void at law should be sustained in equity. She has met with the fact that she asserted no right under it. In fact, concealed its existence until after her husband had contracted the debts against which she now seeks to set it up. there appears to have been no abandonment of possession by the husband, even if the deed was delivered on the day of its date. The supineness of the wife gave to the husband a false credit, and equity will not aid her at the expense of those who have been misled by her lashes, in Blennerhassett v. Sherman, Woods, J., in delivering the unanimous opinion of the United States Supreme Court, observed, but where a mortgagee, knowing that his mortgagor is insolvent, for the purpose of giving him a fictitious credit actively conceals the mortgage which covers his entire estate and withholds it from the record, and while so concealing it represents the mortgagor as having a large estate and unlimited credit. And by these means others are induced to give him credit, and he fails and is unable to pay the debts thus contracted. The mortgage will be declared fraudulent and void at common law, whether the motive of the mortgagee be gain to himself or advantage to his mortgagor. But there must be some evidence of a preconcerted and contrived purpose to deceive and defraud the other creditors of the mortgagor, of which scheme the withholding of the instrument from the record constitutes a part. It is said in Curry v. Macaulay, when the mortgage was executed and delivered, nothing further was necessary to its validity as a complete transaction. It has, therefore, been held in Pennsylvania by a long series of decisions that, as between the parties, a mortgage takes effect upon delivery, and that an unrecorded mortgage is good against an assignee for the benefit of creditors. SS 236, Evidence Alliumt. In a controversy which arose in Mississippi, it was decided that a deed of trust in the nature of a mortgage, valid on its face, and not made or received with any intent to defeat existing or future creditors, may nevertheless be held to be fraudulent and void as to all creditors, existing and future, by evidence alien showing the conduct of the parties in their dealings in reference to the deed. The principal circumstances relied on in this case to avoid the deed were the facts that the grantor retained possession of the property, and that the deed was withheld from record. This enabled the mortgagor to contract debts upon the presumption that the property was unencumbered. The court said, the natural and logical effect of the agreement and assignment, and the conduct of the parties thereto, was to mislead and deceive the public, and induce credit to be given to Bagot, which he could not have obtained if the truth had been known. And therefore the whole scheme was fraudulent as to subsequent creditors, as much so as if it had been contrived with that motive and for that object. SS 237, Concealment in Fraud of Bankrupt Act, in Blennerhassett v. Sherman, a very important case reviewing the authorities concerning suppression and concealment of transfers. The court held that a mortgage executed by an insolvent debtor with intent to give a preference to his creditors was void under the Bankrupt Act. It appeared that the creditor had reasonable grounds to believe the mortgagor insolvent, and knew that the instrument was made in fraud of the provisions of the Bankrupt Act, and that the mortgagee had, for the purpose of evading the bankrupt law, actively concealed the existence of the instrument, and withheld it from record for a period of more than 2 months. The security was avoided, notwithstanding it was executed over 2 months before the filing of the petition in bankruptcy. SS 238, Absolute Conveyance by Way of Security. It is familiar learning that a deed absolute on its face may, despite the statute of frauds, be shown by extrinsic evidence to be a mortgage, and that the relationship of mortgagee and mortgagor with all the usual incidents may thus be established. If, however, the transfer was not devised by the debtor to defraud or delay his creditors, or if it was so designed, and the trustee or mortgagee afforded no aid in carrying out the intention of the principal, the transaction is valid, though perhaps open to suspicion. A conveyance by way of security must be in all respects as clean and clear as a conveyance for permanent ownership. If no fraud was in fact intended, the security may be enforced, but if the debtor made a secret reservation, or the creditor comes into court with a fraudulent claim of an absolute title, other creditors may avoid the transaction. Williams, C.H. J., said in Barker v. French, although it is true that a person may take security for a debt by a deed absolute, or by a bill of sale when it was intended for security, yet there should be no disguise, nor dissembling, nor falsehood. And if the party claims an absolute purchase when the sale was only intended for security, and thereby seeks to protect from the creditors the property of the vendor, and endeavors to conceal the true nature of the transaction, it is evidence of fraud, probably the weight of the better authority. And the sounder reasoning is to the effect that an absolute conveyance by way of security is a badge of fraud which may be removed by evidence of an honest intent. It may be noted with reference to the law upon this subject, that an absolute conveyance by way of security affords a convenient and tempting cover for fraud upon creditors, and the tendency to regard transactions of this kind with suspicion should be encouraged, where the security is corrupted with fraud. Not only can creditors secure it to be avoided, but, as is elsewhere shown, the parties themselves can get no relief. SS 239. Insolvency. Insolvency, as we have seen, does not deprive the owner of the power to sell his property, to pay his debts, whether to one or more of his creditors. Indebtedness or hopeless insolvency is, however, an important element of proof in marshalling badges of fraud to overturn a covenant transaction. The distinction between the right of existing and subsequent creditors, which, of course, has an important bearing upon this subject, is elsewhere considered. A conveyance, to be fraudulent, should bear such a ratio to the indebtedness as to tend directly to defeat the claims of creditors. A heavy indebtedness of the grantor, together with a sale to a relative, of necessity forms strong badges or indications of collusion and fraud, but are not in themselves, unsupported by other material facts, deemed conclusive proofs of fraud. Again, it is said that insolvency of the grantor, although a circumstance which may be taken, together with other material facts, to show a fraudulent design in disposing of property, is not regarded as sufficient of itself to establish it. The sale of all the effects of an insolvent copartnership upon credit at a fair valuation, to a responsible vendee who knew of the insolvency, is not per se fraudulent, nor does proof of a sale upon credit, by a party in failing circumstances, to one who had knowledge of these circumstances, necessarily establish fraud. SS 240. Sales upon credit. It must be remembered that every delay to which a creditor is subjected in the collection of his debt is not necessarily fraudulent. Insolvency, as is elsewhere shown, does not deprive a debtor of the right to sell his property, and if the sale is made in good faith and without any intent to hinder, delay, or defraud creditors, the mere fact that it was made upon credit does not require that it should be declared invalid. The court in Roberts v. Shepherd said, a sale upon credit of part of their property by an insolvent firm is a circumstance which may be considered, with others, bearing upon the question of fraudulent intent, but alone does not necessarily establish it. Certainly it will not do to say that the law presumes that every man who sells on credit does so with intent to hinder and delay his creditors. In Rule v. Phillips, the New York Commission of Appeals, reversing the court below, held that the sale of the entire effects of an insolvent copartnership at a fair valuation, upon a credit ranging from 4 to 24 months, to a responsible vendee, having knowledge of the insolvency, was not fraudulent per se. In the New York Court of Appeals, the principle is enunciated that the mere fact of a sale of his property by a party in failing circumstances, to a purchaser having knowledge of his condition, upon an average credit of 16 months, did not per se establish fraud or an intent to hinder or delay creditors. Where, however, it appears upon the face of the transaction that the parties contemplated a large surplus, and the property is practically protected from forced sales or attachments or levy for 2 years, the instrument will be declared void as hindering and delaying creditors. SS 241. Unusual acts and transactions. Courts and juries are often influenced in favor of creditors by slight circumstances connected with the transaction indicating excessive efforts to give the conveyance the appearance of fairness, or by facts which are not the usual attendants of business transactions. Honesty requires no stratagem or subterfuge to support and aid it. In Adams v. Davidson, the assignee took a fellow clerk with him to witness an attempted transfer of possession, and requested him to pay attention and recollect what he heard. The court were plainly influenced by the evidence of this request, and observed that it was wholly unnecessary if the parties intended to comply with the exactions of good faith in taking and holding possession of the property assigned. To a similar effect is the case of Hartshorn v. Eames. In that case, the court said that there was no indication of great formality in transacting business between the parties, except on the occasion in question, when great precision was resorted to, an accurate calculation and valuation gone into, and the claim of the grantee made to overbalance the valuation. These with other facts led the court to believe that the transaction resembled a farce rather than a bona fide transaction. Again, it is said that bona fide transactions do not need to be clothed with the extraordinary pretense of prompt payment. In Langford v. Fly, the deed of gift contained this clause, "Now this indenture is not to hinder or delay the collection of any of my just debts, but the same are to be paid." A suit for slander was pending at the time, The court said that this clause was evidently the result of a consciousness on the part of the assignor that others might think the deed was made with a fraudulent design, and, as he was otherwise free from debt, it indicated that his purpose in making the transfer was to defeat the judgment which might possibly be recovered in the action for slander. Studied formality and apparent fairness will not save a fraudulent transaction. In Crawford v. Kirksey, it was contended by counsel that very great and unusual particularity furnished badges of fraud. The court observed that if the transaction was consummated quietly and without witnesses, then the complaint would be that it was secretly effected. If unusual publicity or particularity characterized the transaction, this would be urged as a badge of fraud. This, it was said, savored of the water test which in former years was applied to those suspected of witchcraft. If they sank, they were innocent, but they incurred great hazard of losing their lives by drowning. If they swam, they were adjudged witches and perished at the stake. It may be observed that the absence of memoranda, or of any record of the consideration, the failure to take an AC count of the stock, and no agreement as to the exact terms of settlement, a false admission of the receipt of the consideration, unusual clauses in the instrument, a sale to a creditor without a surrender of the evidence of indebtedness, a sale not conducted in the usual and ordinary course of business, conduct of the parties which is exceptional and peculiar, a conveyance of real estate without adequate security, absence of authentic evidence of indebtedness, considerable in amount, other than a pencil memorandum, contradictory and irreconcilable accounts of the transaction given by the vendor and vendee, receiving the rents and managing the estate by the vendor after the alleged sale, under an assumed agency from the vendee, but without any evidence of a genuine agency other than the uncorroborated assertion of the party, absence of means in the vendee, preparation of the deed at the sole instance of the grantee, leaving the business sign the same, employment of the vendor after the sale, sacrificing property for 1/4 of its value, deeding property to relatives without their knowledge, concealment, absence of evidence which is supposed to be within the reach of the party charged with the fraudulent act, neglect to testify, destruction of letters relating to the controversy, tendering security without solicitation, transfers professedly to prevent the sacrifice of the property, taking additional security by way of chattel mortgage on a claim already secured by mortgage on real estate, extending unusual credit. All these are indicia of fraud upon creditors proper for the consideration of the jury or of a court of equity. In cases where a jury trial is not had, on the other hand, a purchase of land by an attorney without making an abstract of title is not necessarily evidence of fraud, nor is a sale by an insolvent of his whole stock in trade upon credit always covenous. Though it is circumscribed by fraudulent presumptions, it has been even held that evidence of a sale by a party indebted of an uninventoried stock of goods on credit to a near relative failed to establish fraud, nor is a trust void because not particularly declared, then the fact that the purchaser has no use for the property is not evidence of fraud. The want of minute accuracy of language and the disregard of the usual forms will not render an assignment void. Nor is it affected by a failure to file schedules, nor by the failure to record it for a few days. Giving more security than is necessary is not itself an indication of fraud. In a Massachusetts case, it was decided that a party was not entitled to offer the testimony of witnesses to the effect that the giving of a mortgage, such as the mortgage in question, would not be in the usual and ordinary course of such business. That was considered to be the question for the jury to decide. SS 242. Effect of relationship upon debtors' transactions. It is said by the Supreme Court of Pennsylvania that there is no law prohibiting persons, standing in near relations of business or affinity, from buying from each other, or requiring them to conduct their business with each other in special form. The sale of property by a father to his son, or by the son to his father, cannot in itself be considered as a badge of fraud, and sometimes the strongest considerations of duty may prompt a son to prefer the claim of a widowed mother. The relationship of a seigneur and assignee, says Finch, J., and their intimacy and friendship, and the preference given to the latter as a creditor prove nothing by themselves. They are consistent with honesty and innocence, and become only important when other circumstances, indicative of fraud, invest them with a new character and purpose, and transform them from equivocal and ambiguous facts into positive badges of fraud. Relationship of the parties, however, is calculated to awaken suspicion, and the transaction will be closely scrutinized. Though the relationship is not of itself sufficient to raise a presumption of fraud, it may be considered, with the other facts, by the jury and rather tends to aid the creditors, for it is regarded as highly probable that a party intending to perpetrate a fraud would look for aid and connivance to a relative rather than to a stranger, when relationship is coupled with secrecy in the transaction. It may, unless explained or justified, be regarded as fraudulent. The same rule applies when the transfer conveys the debtor's entire estate, and other badges accompany it. It may be observed here that the fact that the creditors who obtained judgments by confession bore intimate relations to the debtors, the delay in the levy of the execution, the unusual time and order under which the assignee took possession, and the agency of the same attorney in all the proceedings, though perhaps casting suspicion upon the proceedings, are not in themselves sufficiently strong to sustain an imputation of bad faith or a charge of fraudulent preference. We may here advert to the rule of the common law that a debtor has a right to prefer one class of creditors to another, and that it is error to encourage a jury to take into consideration the exercise of this right as a circumstance of suspicion in deciding upon the fairness of the transfer. The case of Salmon v. Bennett has exerted a potent influence over decisions in this country concerning voluntary conveyances. In the course of the opinion, Swift, C.J., said, "Mere indebtedness at the time will not, in all cases, render a voluntary conveyance void as to creditors, where it is a provision for a child in consideration of love and affection. For if all gifts by way of settlement to children, by men in affluent and prosperous circumstances, were to be rendered void upon a reverse of fortune, it would involve children in the ruin of their parents, and in many cases might produce a greater evil than that intended to be remedied." This rule has been applied to conveyances to wives, as well as to children, grandchildren, and other near relatives. SS 243, prima facie cases of fraud. Taking a deed for property in the name of the wife, which property was purchased and paid for by the husband, who was involved in debt at the time, was said to make a prima facie case of fraud against creditors. In Perkett v. Pollack, the court observed, the control of the property after the alleged sale, the indebtedness of the grantor at the time, the absence of the grantee from the state, and the failure on the part of the latter to show any payment of consideration, were amply sufficient to raise a prima facie intendment of fraud in the transaction. In Ryger v. Davis, the court remarked that when a much embarrassed debtor conveyed property of great value to a near relative, and the transaction was secret, no one being present to witness it but relatives, it was to be regarded as fraudulent. In Wilcoxon v. Morgan, the court said that in addition to the evidence of certain declarations made at the time of the preparation of the conveyance, the relationship of the parties, the fact that the conveyance was made without the knowledge of the grantee, the absence of consideration, and the subsequent long-continued possession and dominion of the premises by the grantor, sufficiently manifest that the purpose of G in this conveyance was to put the estate beyond the reach of his creditors, when it appeared that after the conveyance the debtor had no other property subject to execution, that the grantee was his brother and had not means sufficient to enable him to pay for the property, that the debtor remained in possession and the grantee removed out of the state. These, and certain admissions of the covenantous nature of the transfer, were considered sufficient to show that the conveyance was made to protect the property from creditors. In Danby v. Sharp, it is said that a sale of an entire stock in trade to a clerk in the employment of the vendor is colorable and fraudulent as to the creditors of the vendor, when the vendee has no means, except that he receives $10 a week for his services, and where he pays nothing at the time of the sale, but gives his unsecured promissory notes for the whole amount of the purchase money, and no public notice is given of the change, but the business sign remains the same, and the vendor is frequently about the premises. In Moore v. Roe, the court held that the transfer of all a debtor's property pending a suit against him, the taking of an absolute deed as security for money owing by the debtor, and looseness or incorrectness in stating the consideration of the conveyance, or in determining the value of the property conveyed, were indications of fraud. The further multiplication of these illustrations is a work of doubtful utility. Indeed, the resources of fraudulent debtors are too great, the color and variety of the devices to elude creditors too numerous, to render classification of the different schemes practicable. It is to be noticed that the illustrations last given combine different badges of fraud, and it is very common in creditors' suits to find many of these indicia existing in a single case. SS 244. Comments. Frequent comment is made upon the extreme difficulty of the task of defining and establishing fraud, and it seems to be regarded as impossible to formulate exact rules as to what is and what is not fraud. To do so would be to give to persons fraudulently inclined the power of evading the jurisdiction of the courts by fresh contrivances which might be invented to elude any invariable, inflexible rule. As to relief against frauds, says Hardwick, no invariable rules can be established. Fraud is infinite. And were a court of equity once to lay down rules how far they would go, and no further in extending their relief against it, or to define strictly the species or evidence of it, the jurisdiction would be cramped and perpetually eluded by new schemes, which the fertility of man's invention would contrive. Vice-Chancellor Kin Dursley expressed the modern doctrine in these terms. It was at one time attempted to lay down rules that particular things were indelible badges of fraud. But in truth, every case must stand upon its own footing, and the court or the jury must consider whether, having regard to all the circumstances, the transaction was a fair one and intended to pass the property for a good and valuable consideration. In Jones v. Nevers, Allen, C.J., said, every case must stand on its own footing. But this leads to unsatisfactory and uncertain results. The profession are not given sufficient fixed rules with which to guide their actions, or advise clients, and must resort to the wilderness of single instances contained in the reports to discover analogous cases. The courts protest that it is not permissible to guess at the truth in the discovery of fraud, that fraud must be proved and not presumed, and that speculative inferences are not the proper foundation of a legal judgment. Yet the most casual reading of many reported decisions will demonstrate that transfers of property have been avoided, especially in equity, upon the most shadowy and intangible grounds, and that in many instances innocent purchasers have been the victims of unfortunate circumstances. That on the other hand, fraudulent alienees have constantly escaped the meshes of the law and secured their ill-gotten gains, though the defrauded creditors were inwardly conscious of the fraud which they were powerless to prove, is a matter of common experience. The impulse to color more strongly the constructive indications of fraud, for the protection of valuable rights, is to be encouraged. The degrees of weight to be attached to particular classes of indicia should be carefully considered. For, in the present aspect of the law, the marks of fraud, which assume such prominence in this class of litigation, often, like a two-edged sword, injure both creditors and bona fide alienees.